you think about a prenup in Illinois, or did your spouse just pull one out and you're wondering if it will hold up in court? Most people today think that prenups are only for the rich or for celebrities, but nothing could be further from the truth. Whether you're trying to protect your business, your inheritance, or just avoid a messy divorce down the road, this is what you really need to know about Illinois prenuptial agreement laws. So let's break it down. What makes a prenup valid in Illinois? Illinois law on prenups hasn't changed since 1990. It is still governed by the Illinois Uniform Premarital Agreement Act. And that says that it must be in writing, signed by both parties, and becomes effective upon the date of marriage. And there is no need for any payment or consideration. And most importantly, it must be entered into voluntarily. No pressure, no coercion. We had someone come to us not too long ago, and it was 2 days prior to the wedding. And she said that my fiance wants me to sign this prenup, and I don't have a lawyer. Is that legal? Now that is the kind of situation that courts really scrutinize down the road, and it could make the entire prenup unenforceable. So, what does Illinois law allow prenups to cover? So what does the law allow prenups to cover? Well, in Illinois, it covers who owns what property, how assets will be divided upon divorce or death, whether spousal support will be waived or modified, control over life insurance, estate planning, and inheritances, and the choice of which state's laws will apply at the time of a divorce. And that means, yes, you can eliminate alimony, but only if the right conditions exist. So what can you not put into a prenup? Well, child support or custody arrangements are not allowed. Anything illegal or against public policy, not allowed. And anything that is grossly unfair or unconscionable, those terms are not allowed and will often mean that the entire agreement is kicked out down the road if it is tried to be enforced. So bottom line, if it hurts the kids or breaks the law, it's not enforceable. Now, there's been a recent ruling that has affected how prenups are viewed in Illinois, and that is the case of the marriage of Key Ho. In this case, the husband tried to enforce a separation of assets document from Italy. It was required to be signed under Italian marriage law, but not something that they negotiated together. And our Illinois courts rejected it outright. Why? Because the couple never had a meeting of the minds. There was no real negotiation, no clear agreement, just a document that they had to sign. So the takeaway here, if you are relying on a foreign marriage agreement or just a simple template, Illinois courts will often throw it out if it doesn't meet our legal standards in this state. So what does make a prenup unenforceable? This is where it gets serious. A prenup can be thrown out if it was signed under pressure, fraud, or duress, or one spouse didn't get a full picture of the other spouse's financial assets or debt, and there was no waiver of disclosure, no lawyer, and no time to review. That is coercion. We had someone come to us just last year, and they said, I signed the prenup the night before our wedding. I had no idea that he had 3 retirement accounts. So that agreement likely not enforceable down the road because she didn't have all the information and she signed under duress. So the tip here, always give your partner plenty of time, full financial disclosure, and the chance to talk to their own attorney. And know this, that spousal support provisions get scrutinized heavily. So even if you waive alimony in a prenup, Illinois courts can override that clause if enforcing it would cause undue hardship, especially if it was something that was unforeseeable at the time of execution. So some examples of that would be a long marriage where one spouse left their job to raise their children, a major illness or disability, or a sudden loss of income. So yes, you can waive maintenance, but make sure it is reasonable and both sides understand what they are giving up. So there are some definite best practices when it comes to making sure your prenup is enforced. And these are the ones that we advise clients on. Make sure there is a full financial disclosure, income, debts, assets, all of it. Don't leave anything out. Also, make sure that there is independent attorneys for both spouses and that there is plenty of time to review before the wedding. And avoid super one-sided terms. These rarely hold up. Don't take your chances here. Get it in writing, signed, and preferably witnessed. And as an extra precaution, get it notarized. Getting it notarized only strengthens your case. So why are people using prenups more than ever? Well, you don't need to be a millionaire to benefit from a prenup. Couples are using them now to protect property that they brought into the marriage. plan for blended families, and to guard against student loan debt, and to avoid future legal battles down the road. We often see people in their 20s and 30s getting prenups, not because they don't trust each other, but because they want clarity and peace of mind. In fact, prenups have doubled in use nationwide over the last 10 years, and Illinois is no exception. But even with a rock-solid prenup, what happens when divorce becomes real? Well, here's the truth. Most people make critical mistakes before they even file, and that ends up costing them custody, money, or worse. If you're preparing to file or even thinking about it, do not miss this next video, where I'll walk you through what to do before you sign anything, file any paperwork, or say the wrong thing in court. So let's protect what matters in this next video.